All right, well, welcome everyone. Like I said, this is Con Maciel Carey's 7th installment of its labor and employment webinar series, and we're really happy that you all are here to join us today for an interesting discussion about marijuana and employment law. This is Dan Deacon speaking. I'm joined by my colleague, Ashley Mitchell. And today we're going to be talking about marijuana and how that intersects with employment law. This is obviously a very interesting topic that affects basically every single workplace in the country, and something that a lot of employers struggle with given the patchwork of state laws that have been implemented throughout the country, and even some local laws, right? So we're going to touch today on a few things, but the focus is marijuana in the employment context. We're going to touch on the federal law aspect of things, review some state law nuances, OSHA's anti-retaliation rule, and the impact on post-incident drug testing, and some state-specific marijuana issues. But to kick it off, we're just going to do some quick introductions. Like I said, my name's Dan Deacon. I'm a partner here in the Washington, D.C. office at Con Maciel Carey. Been working in both the labor and employment and the OSHA practice groups for a little over 8 years now. And I do everything from advising and representing employers on a host of different employment topics, wage and hour, claims of discrimination and harassment. And I specialize in a lot of the workplace drug testing issues and marijuana law in particular. On the safety and health side of things, in the OSHA practice group, I represent employers in federal and state OSHA inspections and the litigation that comes from that, post-citation inspections, and the full range of litigation. So with that, I'll turn it over to Ashley to introduce herself, and then we can dive into the agenda and the meat of the presentation here.
Thanks, Dan. Good afternoon, everyone. As Dan said, I am Ashley Mitchell, and I am an associate based in Con Maciel Carey's Chicago office. Like Dan, I practice in both the labor and employment and OSHA practice groups. And as it relates to today's webinar, I have experience advising employers on when to conduct drug testing, how to address those test results, and then defending employer decisions related to the intersection of ADA and marijuana use. And then I have also reviewed some of those written policies and procedures that employers are thinking about implementing as it relates to drug testing.
All right, thanks, Ashley. And right now, we're just going to go over the quick agenda so you get an idea of the topics that we're going to be covering in depth throughout the presentation here. We're going to begin by giving a brief overview of the federal and state law provisions on work-related drug testing. And then we're going to touch on OSHA's post-incident, post-accident drug testing rule under the e-record keeping rule that was actually just amended and finalized yesterday. It's going to be published in the Federal Register in just a couple days on Friday. So we'll touch a little bit on that. Ashley's going to go over some ADA issues and an intersection between marijuana law and drug use in the ADA context. And then we're going to get into some state-specific marijuana laws and employment implications, and some things for you all to consider as you develop, implement, and roll out your drug testing policies, and whether it's a good idea to use zero tolerance policies and some of the trends that we've been seeing throughout various different states and with our clients. So to start out, we really want to kind of touch on the overarching questions that really set the stage for this presentation, and what you as employers should really be asking yourselves when you're creating and implementing your drug testing policies. So the three questions that you see on screen here, right, are: can we legally require current employees to take drug tests? Can we legally require job applicants to take drug tests? There's certain nuances, and you know, the answer to these questions, right, is the answer that everyone hates to hear from a lawyer, right? It depends. It depends on state law. There's a ton of different nuances, and the patchwork of state laws has really created compliance challenges, especially for those employers that operate and cross state lines, right? So when we're talking about current employees, can you legally require current employees to take drug tests? The answer is generally yes. Can we legally require job applicants to take drug tests? Yes, in some cases, and then depending on state laws, there's certain laws that prohibit pre-employment drug testing for marijuana, for example, and there are certain anti-discrimination statutes that we'll touch on later in the presentation. But this is in the context of marijuana law too, right? So we're not saying that you're prohibited from drug testing job applicants for other drugs, but perhaps in the marijuana law context, it may be prohibited. So we'll dive into that a little deeper later in the presentation. But the final question that you really need to be asking yourself and really making sure that you have a firm answer on this is, right, if so, if we're allowed to drug test those current employees and job applicants, how can we ensure we don't run afoul of the law? And really, it should be laws, right? If you are operating in several different states, because like I said, it does create some compliance challenges, given that there are state-specific laws and nuances that will impact your drug testing policy. And in many cases, I don't want to say it's impossible, but it for the most part it's impossible to create one overarching drug testing policy, certainly if you are a nationwide employer that operates perhaps in all 50 states, for example. So this is really how we want to set the stage for you, the overarching questions for really marijuana use and drug testing. These are the three questions that you want to be asking yourself and finding out the answers to these questions. So now we'll just dive into the drug testing issues in employment law and really set the stage on the federal level and some things that you want to be aware of, especially if you're a federal contractor or you have DOT drivers that are regulated under DOT regulations. We're going to touch base on those topics. So really to set the stage and the background of marijuana law. Now, under federal law, there is no comprehensive law that regulates drug testing in the private sector. So the US Supreme Court's ruled that while drug testing does infringe on employees' privacy, it can be necessary in order to protect the health and safety of others. So what this has led to is states coming in and regulating drug testing laws. And what that has created is, like I said, compliance challenges for employers that are certainly operating in all 50 states or a number of different states, because there are certain laws that, for example, prohibit pre-employment drug testing for marijuana, some anti-discrimination statutes that prohibit you from taking an adverse action against an employee if they hold a marijuana card under the state's medical marijuana program. So it's really important to take a look at those state-specific laws because the Supreme Court and the federal government has basically left it up to states to regulate drug testing as it is under those state laws. So what does the federal government say about drug testing? Like I said, it really doesn't impact the private sector, the private sector employers. Those are regulated by state laws, but there are certain federal laws that do come into play. For example, if you are a federal contractor or you have employees that are regulated under, for example, the Department of Defense or the Department of Transportation regulations. So the Drug-Free Workplace Act, this applies to federal contractors. And basically, if you have federal contracts worth $100,000 or more, or you're an employer that receives any federal grants of any size, that is when the Drug-Free Workplace Act kicks in. Interestingly, it does not require drug testing. So there is no provisions or policies that say you must drug test in these certain situations. What it does require is that you implement a drug-free policy, and you need to create a written program under the Act. And there is certain oversight to ensure that, as part of receiving that federal contract or that grant, that you are complying with the provisions of this Drug-Free Workplace Act. Marijuana in particular is a Schedule I substance under the Federal Controlled Substances Act, so it is still illegal under federal law. That gets important when we're kind of navigating these state law issues. But for purposes of, if you're covered under the Drug-Free Workplace Act, marijuana, that's still an illegal substance. You should be taking that into consideration if you are implementing a policy under that act, right? When it comes to DOT and DOD covered employees, for example, if you have regulated drivers, you're in warehousing, shipping, that industry, and you have drivers that are regulated under DOT, there is certain testing requirements that do include provisions, or I should say require you to test for marijuana. And this is for public safety and security positions generally. So just as an example, we're going to cover kind of the DOT drug and alcohol testing provisions and how that may impact you if you have DOT drivers. And this isn't to say that if you have DOT covered employees that it applies to all your employees, right? This is just applicable to those drivers or those employees that are covered under the DOT regulations. So under that, marijuana use is prohibited, and you are required to test for marijuana for those DOT covered employees. And there's a variety of different stages in which you are required to conduct drug tests, including at the pre-employment stage, post-accident, reasonable suspicion, there's random drug testing protocols, and then return to duty follow-up. If there is a positive drug test and they're wanting to get back into the DOT covered position, there are certain provisions and really detailed provisions that you need to follow on those return to duty and follow-up tests. As part of the DOT program, employers also need to obtain the drug and alcohol testing information from an applicant's previous employers over the past 2 years. So you're getting that from the DOT clearinghouse. And there's also the specific regulations on how alcohol and drug testing is actually to be conducted, including the mandatory random drug testing, but also the provisions in which how you actually conduct that drug test. So if you do have employees that are covered under, for example, the DOT regulations or the Department of Defense regulations, those are provisions that you really want to carefully review when drafting your drug testing policy, because it will certainly kind of influence how you roll that out, especially as it relates to those covered employees. It's a requirement, it's not a suggestion. So make sure that you're doing your due diligence in following those types of programs if you have those covered employees. So I'll turn it over to Ashley now, and she's going to go over some of the state law implications, and then we'll dive into the OSHA post-incident drug testing rule.
Thanks, Dan. So as we turn to some of the state law implications, as Dan already mentioned, there are a patchwork of state laws. So some of this will vary depending on where your operations are located. But in the context of state law related to the marijuana drug testing, employers will generally have a right to do the testing unless the state imposes specific restrictions. So it is the case that some states only authorize the testing for employees in safety-sensitive positions, whereas other states explicitly authorize random testing under, a list of circumstances. And then there are states that have no restrictions whatsoever, for example, Michigan. But the fact that your state does not have any drug testing restrictions does not give, you as the employer carte blanche in terms of the decisions of whether and how to test for drugs. And so on the next slide, we see here that there are some considerations for pre-employment, for example, where some states will require that an offer of employment be contingent upon passing a pre-employment test. Some states also require that before that test is administered, employers provide written notice to the applicant or, indicate in the job posting that the testing will be required. On a practical note, if employers are conducting this pre-employment screening, it should generally happen after there's a conditional offer of employment, but before the employee begins actually doing the work. When we think about random testing, again, we are subject to the patchwork of state law. I can say here that states like Georgia, Virginia, and Pennsylvania have no restrictions. Maine has some restrictions. Vermont prohibits random testing altogether. And then localities like San Francisco and Boulder, Colorado also prohibit random testing. If you are in a jurisdiction where random testing is permissible, on a practical note, it's important to make sure that the random testing policy is not deployed or used in a discriminatory manner. And so what that means is if you are selecting employees at random, you want to make sure that it's truly at random and not based on one of those protected categories such as race, age, gender, things of that nature. So yes, it's important to make sure that to the extent you are permitted to do random drug testing under the state law, you are doing so in a non-discriminate way. There will be some workplaces that are going to be subject to a collective bargaining agreement or under a CBA. And if it is the case that your workplace is covered by a CBA, before implementing a drug testing policy, it's imperative that you review that CBA to determine whether drug testing is covered. If the CBA is silent on the matter, you do have a duty to bargain with the employee's representative, and a failure to do so could result in an unfair labor practice charge. So again, key takeaway here, if you are covered by a CBA, in addition to whatever state laws may apply, you will also need to check with your CBA and see if drug testing is covered, what circumstances it permits, and then if the CBA is silent on the matter, you do have a duty to bargain over what would become the drug testing provision before implementing such a policy. And then on the next slide here, we see that there are other legal concerns. And so even though the state where you're operating and doing business may allow you to engage in drug testing of employees and applicants, it could be the case that there are legal claims based on who's tested, how the test was conducted, or how the results were used. And so, it's important to follow your state's requirements. So for example, in many states like Maryland, an employee can bring a legal challenge against an employer who conducted the testing but did not have a legitimate business reason to test or did not provide documents that the employer received following the positive test result. When we think about discrimination claims, I touched on this a little bit earlier, but I'll get into it in more detail here. It's imperative that if you have, random drug testing, that you don't single out certain groups of employees by their race, by their age, by their gender, or any other protected characteristic, because you don't want to face a potential claim for discrimination. And so when you're thinking about how to implement a policy, you truly want to make sure that it applies to everyone, either in the job title or who has the same duties and responsibilities equally, so that you are not running the risk of a discrimination claim. When we think about invasion of privacy, I know Dan mentioned earlier that the Supreme Court has said, employers do have a need to know for some of those safety and security reasons. And so even if it is the case that an employer is allowed or required to test for drugs, there is still a concern about the way in which the drug test is conducted. And so, for example, an employer who requires employees to disrobe completely for the drug test or provide a urine sample in front of other folks could face liability for invasion of privacy. And so you certainly want to be sensitive to the way in which the actual test is administered. And then finally, as we think about defamation, an employee might have a valid claim for defamation if the employer publicizes an employee's positive test results, if it's the case that the employer has reason to know that the test might not be accurate. And so this could come up if a retest, right? If an employee tests positive the first time, and then there's a retest that shows that the first test was a false positive. It could also come up if the employee appeals the first test. And so publicizing that positive test result could leave the employer liable for revealing the results of the positive test beyond those who have a need to know about the test results. And so with that, I will turn it back to Dan to discuss OSHA's final rule.
So we're going to dive in now to OSHA's e-record keeping rule and the impact it has on post-incident drug testing. And just to kind of address some of the questions that are coming in, we did have a question about New York law and the restrictions on the types of drugs that can be tested. I think it was back in 2021. The fall of 2021, that New York did pass a law restricting the ability to drug test for marijuana in certain contexts, but there is no limitation on the type of or the manner in which you can perform drug tests in New York. So that is one nuance there in New York that is somewhat of a recent update, that marijuana law has changed a bit over the past couple of years, and you are restricted in certain situations from conducting testing, I should say, in your drug panel for marijuana. And then let's see if there's other questions here. Do most states require employers to utilize the traditional urine testing, or do they allow them to use some type of impairment test like breathalyzer? Are states moving in the direction of using impairment tests or allowing employers to use impairment tests? So this again is a very state-specific question. So there are certain states that outline exactly how you are required to conduct drug tests, and others that don't state how you should do that in one way or another, and it's left up to the discretion of the employer. But that is a very state-specific question. Typically, we're seeing most employers using tests that are kind of operated by a lab that kind of understand those state nuances and can help you navigate that process from the get-go. All right, so now turning our attention to OSHA's post-incident drug testing rule. The genesis of this rule kind of started way back, gosh, eight or so years ago, and the final rule was published in May of 2016. And this was really focused on the e-record keeping submission. So for those covered employees that are required to submit 300A data on an annual basis by March 2nd. That was really the bulk of the rule and the substance of it, but there were certain anti-retaliation provisions that were outlined as well, one of them being related to post-incident drug testing. So the concern here was that drug testing could dissuade a reasonable employee from reporting a work-related injury, and because it is considered an invasion of privacy. So what that rule outlined, and this is really related to OSHA's regulation under 29 CFR 1904-35, its anti-retaliation provision. It prohibited blanket post-injury drug testing policies. So if you had, or you currently still have, a policy that says after every single employee injury, they'll be subject to a drug test, that's something that OSHA takes issue with and prohibits it outright. And this isn't in a regulation per se, but it is in the preamble to the final rule. So, you know, the 300 plus pages of explanation that OSHA outlines for its justification for issuing the rule and the purpose behind that, that's where there's a pretty large section that's covering blanket post-injury drug testing policies and the post-incident drug testing issues. So what OSHA was really concerned about here is that post-injury drug testing could be used as a form of discipline, and it would discourage employees from reporting those work-related injuries. And the whole intent of the rule, in addition to the e-record keeping portion, is to encourage employees to report those injuries and illnesses. And this is all in the workplace safety context, right? To make the workplace a safer place, to learn about those injuries and illnesses and make any corrective actions that are necessary to prevent or mitigate the risk of that happening again. So the rule itself, it was only related to post-incident drug testing. So it didn't have any impact on pre-employment testing, random testing. If you're required to conduct post-incident drug testing under a state or federal law, that was still permissible. So it didn't have any effect on that and the intersection between those requirements. For example, if you have DOT covered employees, like we discussed towards the beginning of the presentation, there are mandatory post-incident testing requirements. Those are not impacted by OSHA's rule at all. Likewise, if post-incident drug testing is required by a workers' compensation insurer, for example, for premium reductions, those policies that require the post-incident drug testing under the workers' comp policy, OSHA's rule does not affect that either, and you won't run afoul of OSHA's anti-retaliation rule if your workers' compensation insurer requires it. So the real kind of crux of the rule here was that post-accident and post-incident drug tests are permissible when it is likely to have contributed to the injury and the test can ID present impairment. Now that present impairment part has been softened. That really only applied to alcohol testing at the beginning of the rule, but that was how the rule was written in 2016. So the part about, the post-incident drug testing piece had to identify present impairment. That is no longer a requirement. That was softened very shortly after the rule was finalized, realizing that we can't ID present impairment for things like marijuana, right? But with that being said, and we always advise this to our clients when we're doing a post-accident test, it's important to also conduct that reasonable suspicion analysis simultaneously, right? Because that is the way in which you can identify or at least substantiate that someone may be presently impaired. And this certainly is important in the context of certain states, right? Where if someone is protected under state law, under an anti-discrimination statute, for example, if the employer is prohibited from taking an adverse action because of someone's participation in the medical marijuana program, or there's lawful off-duty conduct laws that come into play, which we're going to touch on later in the presentation as well, that's one way that you can still take adverse action in the event of a positive post-incident result. If you have that reasonable suspicion analysis and you can confirm that someone was impaired, likely impaired at the time of the incident, that is one avenue that you can continue basing your adverse action on as you move forward. So, like I said, the rule prohibits drug testing employees for reporting work-related injuries without an objectively reasonable basis, and this is directly from the preamble itself. So you are prohibited from those blanket post-incident reporting or blanket post-incident drug testing requirements. You really need an objective, reasonable basis for doing it, and it can be used as a tool to evaluate the root cause of a workplace injury or illness. So what really goes into that? There's kind of 4 factors that OSHA outlined in the preamble. One, whether the employer has a reasonable basis to conclude drug use could have contributed to the injury. So that's a little circular, right? But it really is a fact-specific analysis that you need to undertake when doing this. And we're going to kind of touch on how you do that in the next slide. 2, whether other employees involved in the incident also are tested. 3, whether there's a heightened interest in identifying drug use because of the high hazard nature of the work. And 4, whether the drug test is capable of measuring impairment at the time an injury occurred. That was only considered for alcohol tests. And like I said, that has since been softened and really is not applicable anymore at all. But this was the basis of the rule as it was written in 2016. And then in October 2018, we had this memo where OSHA really softened its position on both the safety incentive programs and post-incident drug testing programs. We don't really need to touch on the safety incentive program piece because that's not part of the presentation today. But as it relates to post-incident drug testing, they basically said you can use post-incident drug testing to evaluate the root cause of a workplace incident that harmed or could have harmed employees. So you still need that objective, reasonable basis for doing that. And they provided some examples and further guidance on how that would work, right? So if you had a situation, for example, where an employee is stung by a bee, that would not be, a reasonable time to conduct that post-incident drug testing. But if you have a situation, involving a forklift operator, for example, or a crane operator, and the incident involves activities by multiple employees. If you're using a post-incident drug test to evaluate the root cause of the workplace incident, that is perfectly acceptable. But you want to make sure that you're drug testing those employees, all of those employees, I should say, that could have caused or contributed to the incident. So not just the person that was injured or the operator themselves, but perhaps both, right? Or in the crane operator situation, if you have someone that's doing the switching and rigging of the crane, you have other employees in areas perhaps where they're not supposed to be, you have the operator. Perhaps based on your investigation, it's reasonable to drug test all 3 of those employees, or 2 out of the 3. It's really fact specific, but you want to use it as the root cause to identify whether drugs or alcohol could have caused or contributed to it. And you really need to broaden that analysis to any employees that may have been involved in that incident that could have caused or contributed to it. So now I'll turn it over to Ashley to touch on the ADA considerations.
Thanks, Dan. So although drug testing is generally permissible under the ADA, disability discrimination is the most significant legal risk when deciding whether to engage in drug testing. So, the primary reason many organizations will require drug testing is to keep the workplace safe, right? It can be argued that as an employer, you have an obligation to ensure that your workplace remains drug-free to create a safe environment for all employees. And in essence, it's a legal liability. It could be a legal liability for employers that haven't taken steps, including drug testing, to keep impaired individuals off the premises, especially those individuals in safety-sensitive roles. This is also the primary reason that drug tests are, in fact, legal. That obligation to keep a safe working environment trumps an individual employee's privacy rights in the eyes of the law. And so here on the next slide, we look deeper into disability discrimination. Since some disabilities require medication, which may show up in drug test results. So after an employee, if it's the case that you've undertaken your analysis on your state law, if it's post-incident under, the OSHA Act, you've undertaken your analysis, determined that it is acceptable to administer a drug test. If it is the case that after you administer that test, the result is positive, how you respond to that positive test result will be situation specific. So if, for example, the employee drug test shows the presence of what could be a prescription medication, such as an opioid or, depending on the state, marijuana, you would want to give that employee an opportunity to provide an explanation before taking an adverse employment action. And so if it's the case, that positive test result is from a prescription medication and the employee explains that prescription medication is being taken in a way that's consistent with how that medication was legally prescribed, then it may be discriminatory to hold that positive test result against the employee. And depending on the situation, the test result, and the employee's role at the company, at the work site, that employee may be entitled to a reasonable accommodation. I do also want to take the time to touch on addiction as a disability, because it is important to note that the ADA does protect disabled individuals from discrimination if they are qualified to do the job, and addiction can be a disability in some cases. In particular, in this context, those who have recently recovered from a drug or alcohol addiction may be protected if they are now qualified to do the job and they are no longer abusing drugs and alcohol. But it's important to say that this protection does not extend to those who are currently using or abusing drugs in a way that is against company policy. And so here, by way of example, opioid addiction, sometimes called opioid use disorder, or OUD, is itself a diagnosable medical condition that could be an ADA disability. And so employees who suffer from OUD may be able to get a reasonable accommodation, but employers may deny that request for an accommodation if the employee is using the opioids illegally, even if the employee has OUD and that OUD is a disability. And so the key takeaway here is that before an employer takes an adverse action because of the positive drug test, you will want to provide the employee or job applicant the opportunity to provide an explanation for that positive test result. And then you'll want to evaluate that explanation to determine whether the employee or applicant is legally using the substance that they tested positive for and could therefore qualify for a reasonable accommodation. And then we talk about reasonable accommodations more here. I know I've used this term a lot, and I'm sure a lot of you are already aware of what it means. But just as a reminder, the ADA requires covered employers to provide qualified individuals with a disability a reasonable accommodation, so long as the accommodation would not cause an undue hardship for the employer. And so if an employee or job applicant is legally using a prescription medication and is not disqualified for the job by federal law, it may be the case that you have to provide them with a reasonable accommodation before taking an adverse employment action, be it firing or rejecting, the job applicant. But I do want to say, for all of this talk about reasonable accommodation, an employer does not ever have to lower its production or performance standards, eliminate essential functions of the job. So think about those as fundamental duties. You don't have to pay for work that is not performed, and you certainly are not expected to excuse illegal drug use on the job as a reasonable accommodation. Some factors that you might think about, if you have concerns that the employee's positive test result could interfere with their safe and effective job performance, that's a valid concern, and you need to support that concern with evidence that shows that the employee or applicant poses a significant risk of substantial harm. So, certainly if you think that is valid, you just want to make sure that you are collecting evidence, as you're going through the interactive process, learning more about the employee, about their disability, about, whatever medications they are taking, about how those medications impact the employee's ability to perform their job safely. You want to make sure that you are, asking for information that will support your concern about whether or not that prescription medication would interfere with the employee's job performance and pose a significant risk of substantial harm. And then we will take a look at a case, Barbudo v. Advantage Sales and Marketing. And so in this particular case, out of Massachusetts, the former employee used medical marijuana at home, important to note, at home, to treat her Crohn's disease, and she was fired from her marketing position after she failed a drug test. And so after her termination, the employee filed suit alleging, disability discrimination, and the Massachusetts court held that, this former employee was disabled and rejected the company's claim that the employee's use of an illegal drug under federal law rendered an accommodation unreasonable under state law. And in doing so, the court relied on language in the Massachusetts state medical marijuana law, which prohibited the denial of any right or privilege on the basis of medical marijuana use. And so here the court held that, quote, where a handicapped employee needs medication to alleviate or manage the medical condition that renders her handicapped, and the employer fires her because company policy prohibits the use of this medication, the law does not ignore the fact that the policy resulted in a person being denied employment because of her handicap. Now, notably, the court did decline to provide a private cause of action under the state medical marijuana law for wrongful termination, given that there was a remedy under the discrimination law. And I also want to note that the defendants in this case, the employers did not argue federal preemption. So there's still, some other avenues that might be considered as case law in this area develops. But a key takeaway here is that, you want to make sure that as you're making these employment decisions on the basis of positive test results, that you are considering, giving that employee a chance to explain their use of whatever the substance is, and B, that you're not, in taking an adverse employment action, it would not be considered discriminatory because the employee's drug use is related to a protected disability or, the state's medical marijuana protected use. So with that, I believe I'm turning it back over to you, Dan.
Yes, that's right. All right, so now we're going to dive into marijuana laws and kind of review some of the areas and states where marijuana is legal to some extent, either in the medical context or the recreational context. Just want to address one of the questions in the chat about the new California law that's coming into effect in 2024 and how that's going to impact drug testing, specifically as it relates to marijuana. So basically, this is a law that kind of implements the anti-discrimination elements that we're going to talk about in a few slides here, that kind of prohibits you as an employer from taking adverse action for lawful off-duty conduct, and really protecting those employees and those people that use marijuana outside of the workplace. There are still certain ways in which you can test for THC. So, the California law, it effectively prohibits tests that rely on or test for non-psychoactive marijuana metabolites. But there are a couple different tests that you as employers in California may still be able to use and implement. For example, if you use tests that screen for psychoactive THC instead of non-psychoactive metabolites, that is still permissible. This is something that's kind of being navigated in the moment right now. So we're still looking at ways in which employers can still test for those types. You can still test using an impairment test, which is kind of outlined under that law as well, where it measures an employee against kind of their own baseline performance. And these tests are kind newish. They're administered through a phone or some type of tablet application that really measures an employee's cognitive and psychomotor capabilities against a rolling baseline. So there's a little more work that goes into that. But this, again, is a new law and still working through some of those nuances, but happy to talk about that afterwards, or if you have any follow-up questions about that in particular too. So marijuana use in society, and this is really dating back 6 years ago, a Gallup poll, and this is kind of meant to give you just an overview of the trend and where things are heading. So 45% of Americans have tried marijuana and at least 12% actively use it. That was in 2017, 6 years ago. Right now, that's much, much higher. 1 in 8 people currently smoke marijuana, and we're at the highest percentage of people trying marijuana since the late 60s. There is a higher use among men, and there's increasing number of jurisdictions, and really this is across the aisle, those folks in favor of legalization of marijuana to some extent, and we're going to show that on the next couple slides here. And in 2018, the subsequent Gallup poll revealed that 65% of Americans believe smoking marijuana is morally acceptable. And again, these are 5-6 years ago. That those numbers have only increased since then. We're looking at currently, I think, over 7,500 dispensaries nationwide, and in some jurisdictions where it's been legal for quite some time on the state law, either in the recreational context or medicinal context. There's some areas where there's, excuse me, dispensaries, every few miles, and the general public has access to marijuana, with certain restrictions, of course, depending on the state, within 30 minutes. So that's really kind of setting the stage. And as you can see, over the past few years, we've got a number of states that have implemented new marijuana laws, again, on the recreational side, both the recreational side and the medicinal side. This slide shows those 40 states in DC that have legalized marijuana for certain medical conditions. So again, we're talking the overwhelming majority of states have it legalized in some context for medicinal purposes. There's also a couple of states that aren't on here that have kind of soft marijuana laws, so to speak, where CBD oil is permissible, but not the sale of THC products, for example, Georgia. And moving on to the recreational side of things, this is also increasing. There's several states currently that have proposed bills to legalize marijuana in the recreational context, and also a few that have proposed laws to legalize it in the medical context as well. But this is the list of the 22 jurisdictions that have legalized it for recreational purposes, typically for those individuals 21 and over. So now we're going to kind of talk a little more in depth about medical marijuana in the workplace. And that there's a bit of a dichotomy here, right? Because it remains illegal under federal law, but there are the majority of states, right? 40 jurisdictions that have legalized some form of marijuana use in the medical context. And what that does is creates a bit of uncertainty for employers when trying to implement and apply workplace policies across state lines, because not all of those state medical use laws necessarily provide protections for employees. So this is another area where you need to kind of do your due diligence and do your homework to see whether you as an employer can take adverse action against employees for positive marijuana tests. And likewise, you also need to consider those laws under federal law and ADA, what Ashley just talked about. So there's a couple different considerations there when you're implementing and creating that drug testing policy when we're talking about medical marijuana use, and it's a really sensitive topic, but again, state specific, and you really need to dive into those state specific nuances in developing your policy. There's a bunch of different state laws, not only on the anti-discrimination front, but specifically require you to provide an accommodation for medical marijuana, or in the other context, compliance with certain drug testing procedures as well. So the state anti-discrimination statutes that I've referenced a couple times now. There are quite a few states that have anti-discrimination provisions in their medical marijuana laws that prohibit you from taking an adverse action against an employee for either participation in the state marijuana program or a positive drug test, right? So this is really the list of those states, and there may be more soon. And if we take a look at some of them, for example, Maine, that the state anti-discrimination statute also applies in the recreational context too, and we're seeing more of that develop as time goes on. And we'll talk about lawful off-duty conduct laws, which aren't necessarily anti-discrimination statutes, so to speak, but they have the same effect. But these are the states that have anti-discrimination provisions specifically outlined in their medical marijuana laws that you want to be aware of when drafting and implementing that drug testing policy. So the overarching question here when it comes to marijuana law, is it lawful to terminate an employee who tests positive for marijuana? And the answer, again, it really depends on which state you're located and whether there are employee protections for medical and or recreational use. So, you know, generally, if you have an employee that tests positive for marijuana in a host of states, because we just went over the anti-discrimination statutes in that list, that's only a small subset of the 40 in which, for example, in the medical context, that specifically outline those anti-discrimination statutes. So there are a good number of states in which you can test employees for marijuana and you can still discipline them. But again, it's important to take a look at both the anti-discrimination statutes, if they're applicable, consider any ADA issues that may arise, and really kind of flesh that out. And it's a fact-specific analysis. So again, the overarching question, is it lawful to terminate an employee who tests positive for marijuana? That answer really depends on the answer to a number of different questions that take some time to sift through and go through each state's law and make sure that you have a full understanding of those prohibitions or any provisions that restrict you from doing so. But like I said, the answer is generally yes. Most states do allow employers to prohibit use of marijuana on the employer's premises as well as any on-the-job intoxication. So that again gets back to doing that reasonable suspicion analysis in conjunction, you know, with any, for example, post-incident test, or even if you have, you know, a report of an employee that is believed to be intoxicated, you get a report from a manager or another employee. Make sure that you're doing your due diligence and doing that reasonable suspicion analysis as well. So the answer is right. Generally, yes, but bear in mind there's a few states that do have those specific anti-discrimination statutes that you want to take a close look at that may impact your ability to do so. And now we're going to turn it over to Ashley. She's going to go through some of those lawful off-duty conduct issues and some of the provisions in certain states that prohibit you from taking adverse action from lawful use of marijuana off-duty.
Thanks, Dan. So the key question here is, can an employer discipline an employee for off hours and off-site use or influence? And again, because this is state specific, it's going to depend on the state, the way the statute is written, and, you know, perhaps there will be some other considerations, you know, whether this particular employee is subject to DOT and DOD regulations. In some states, such as Arizona, Delaware, Rhode Island, and Minnesota, the statute expressly prohibits employers for firing an employee for a positive marijuana drug test if that employee holds a valid marijuana card. By contrast, there are other states like California, Colorado, Montana, Oregon, and Washington, based on their statutes or case law, that say that employers may lawfully implement zero tolerance drug use policies regardless of the legality of marijuana use under state law. That said, as marijuana laws continue to evolve and expand, these laws may be reconsidered. As we continue to think about lawful off-duty activities, in the next slide, employers taking action against employees with positive drug tests, you could run into issues with statutes that, permit lawful off-duty activities. So in some states, depending on how that statute is written, an employee who tests positive for marijuana could claim that they were protected from termination so long as the use of the drug occurred during non-working hours. Typically for lawful off-duty statutes, they're aimed at protecting the employee's right to free speech so that they cannot be fired for engaging in political activities or just activities that their employer may disagree with. However, these statutes also apply to personal and lifestyle decisions. So again, it's going to depend on that case law and the jurisdiction and how it has been applied to the existing use of marijuana. On the next slide, we look at a case out of Colorado that goes more into detail on these lawful off-duty activities. So in Coates v. Dish Network, Brandon Coates was paralyzed in a car accident when he was a teenager and was a licensed medical marijuana user at the time that he was working at Dish Network's call center. The company required him to take a drug test, which he, of course, failed. And as a result, Dish Network terminated Mr. Coates' employment based on its zero tolerance policy. Coates then brought an action alleging wrongful termination under Colorado's lawful activities law, which prohibits employers from firing employees for engaging in legal activities while not at work. So the statute, not specifically tailored to marijuana, but just legal activities while not at work, in this case, medical marijuana. At court, Mr. Coates argued that his position was not hazardous, that he was not in an executive position that would require decision-making, and most importantly, that he was never under the influence of the drug during work time or on company premises. Mr. Coates also argued that Dish Network knew of his status as a medical marijuana patient when he was hired, making their claims of a zero tolerance workplace invalid. Dish Network, on the other hand, argued that it was lawfully entitled to its zero tolerance policy, and in any event, even though marijuana is explicitly legal under Colorado law, marijuana usage could not be considered a lawful off-duty activity due to its federal status as an illegal controlled substance. And the Colorado Supreme Court upheld a decision for the employer. And in Colorado, they found that the termination decision was, in fact, lawful. And so the key takeaway here is, you're going to really have to do your due diligence and not just look at the statutes, but see if there are some case law out here, because at least in Colorado, the termination decision for Mr. Coates, that court held that it was lawful, once he failed that drug test, that he was not subsequently protected by Colorado's lawful activities law. And so, given that Colorado has been at the liberal forefront of legalizing marijuana, the fact that the Colorado Supreme Court affirmed the ruling in favor of the employer and determined that Mr. Coates was lawfully terminated certainly strengthens the rights of employers in all states to terminate employment or otherwise discipline employees who fail drug tests as a result of marijuana use, regardless of whether or not that use was legal under the state law. And so as we near the end of today's presentation, here are some practical aspects to consider when thinking about implementing policies in your own workplace. The first being, will a zero tolerance policy on marijuana reduce your pool of qualified candidates to an unacceptable level? The second being, will failing to test for marijuana lead to increased workplace injuries or absenteeism? And then another consideration is, will treating marijuana differently than other, quote, illegal drugs create problems, and divisions within your workforce? And then finally, in thinking through the implementation and continued use of zero tolerance policies, thus far, there are not any indications that employers are relaxing standards for jobs that are safety and critical. Again, you do have that responsibility to make sure that folks in safety sensitive roles are not acting under, impaired conditions. But drug policies for positions that entail relatively low risk of injury or error, such as those clerical jobs, knowledge economy jobs, it's a different arena. And so, zero tolerance policies are still okay. But when you have such a policy, it's important to make sure that when you have such a policy, you're making that statement and putting a flag in the ground and taking a strong stand. And you want to make sure that, that's what you want to do. And if you do, that is okay. And it can absolutely be a good thing. It sends a cultural message. But it's also important to keep in mind that taking such a strong stance takes away any flexibility that you have. So you just want to make sure that, in implementing a zero tolerance policy, you're thinking it through pros and cons, and then, making the decision that's best for your workplace. That being said, it's not a zero-sum game. So there's nothing wrong with tailoring your drug testing to the job. If there's a fitness for duty component, for those particular positions, you can revise job application forms to state clearly on the signature page that any job offer is contingent on drug testing results, which would hopefully help to minimize the frustration of finding a promising candidate. Before you go through the process, make that conditional offer of employment, only to learn, that the candidate is disqualified for employment. And then as a concluding note, you should also think about improving supervisors' training so that they are able to identify possible signs of impairment, as they're going throughout the workday, as they're observing teammates and workers. And then review your policy on drugs at least once a year, double checking to see if there are any updates in the particular state that you work in, the locality, and just making sure that your policies are up to date in that way. And then, maintaining productivity and protecting fellow employees, are always going to be important reasons for testing applicants as well as current employees. And so with that, I turn it over to Dan to close us out.
Thanks, Ashley. So just to wrap us up here, we'll answer some of the questions that have come into the chat, but just wanted to highlight for you all the blog articles that we publish on basically a weekly basis, both on the OSHA side and the employment front. We have a California, Cal OSHA specific blog. So we're posting on a variety of different topics. Quite often drug testing and marijuana issues is one of them. So please feel free to follow along those. And then if you want to tune into any of our other webinars that we have coming up, the next one will be in September on managing employee privacy rights. Please feel free to sign up for any of those. And then finally, if you have any additional questions after today's presentation, please feel free to reach out to me or Ashley at any time. We'd be happy to discuss any of these issues. I know we covered a lot of topics today, and there's so many different state nuances. You could probably provide an hour presentation on each individual state, right? So please feel free to reach out to us about any specific questions that you may have. about your particular jurisdictions. And then again, if you want to ask us a question now in the chat box, be happy to answer them here. And some of the questions that we'll start with here: for pre-employment testing for marijuana, do you see employers moving towards a type of test, for example, urine or hair follicle? Traditionally, it's been urine samples. I think it's somewhere around 90% of employers use that, and that's the industry standard. That's what's outlined in the DOT regulations, and that kind of has been historically what has been used. The smaller percentage is urine or hair follicle. But with that being said, you also want to be cognizant of any ADA issues. If people are incapable of providing a certain sample, you may be required to accommodate them in those situations as well. Let's see, is there a definition of what is a safety sensitive rule? There's not a per se definition that you can point to in federal law, so to speak. There's a variety of different areas where this is outlined in certain regulations, for example, but generally you as an employer kind of need to be able to prove that the impaired performance in the position is going to significantly impact an employee's safety and the safety of others. That's generally how we define a safety sensitive role. I see a couple questions here about California in particular, and this is a new law. So the restrictions that are going to be imposed in the next couple months here are significantly different from what they are now, right? So you are going to have a significant change to your drug testing policy and how you implement that. So generally, and this is just kind of a high level overview. So THC is the primary compound in marijuana that causes impairment and psychoactive effects. So when someone uses marijuana, the body basically metabolizes the THC compound and breaks it down into what's called non-psychoactive cannabis metabolites. The California law prohibits you from testing for those non-psychoactive cannabis metabolites. What it doesn't prohibit you from testing is the psychoactive cannabis metabolites. So this is really an interesting nuance where you can still test for THC, a certain compound, and not the other. So you got to be really careful in how you are setting up your drug screen panel. So you're no longer able to test for those non-psychoactive cannabis metabolites, which is typically what is tested in your 5-panel drug screen. So it's going to be a conversation between you and the drug testing provider and whether they can test for the psychoactive THC metabolites, right? And again, California is undergoing a pretty significant change, and there's a lot of different aspects to this, but that's kind of the high level overview of it. So feel free to reach out with any additional questions, California specific or anywhere for that matter, and we'll be happy to answer those. Let's see. Are you aware of any impairment level being established outside of the one in DOT in the marijuana context for employment? Not so much. For example, though, if you are in Illinois, there's the Illinois laws for present impairment under the motor vehicle code. So there are states that are trying to set certain threshold levels in certain laws, but we haven't seen that in the employment law context yet. Let's see, Ashley, do you see any additional questions that we need to answer here? I'm just scrolling through.
No, I think you addressed them all.
Okay. All right, excellent. Well, if anyone has any additional questions, again, please feel free to reach out to us. Our contact information will be in the slides. So thank you all again for joining us today. We hope you enjoyed the presentation and found it interesting. And if you have any questions, feel free to reach out. Thank you.
Thanks, everyone.